okayfm 101.7.
Mami mrai Supreme Court yasha ase edi asem no efiada mo koi videos binum ni ade ye wurase edu nketea betena adwam ene ade be ne si pote na ene mu koi enso se na ebeto aso
yo bakwame Thursday no kaya court no say every year you best hearing no as a Friday every 12 into yenso yeboa me ko pie Friday into ye ko mo ordinarily no bakwame I say you're hearing under the evidence way. Hearing is basically to take evidence. The echo by and say, you could be court home. Yeah, so your Baba started with that. And she one you were witness box. If you were witness box, ordinarily no. Under the Evidence Act, so give it the evidence, your evidence in chief. A lawyer basically do. No account when you want some improve of your case. But one will say high court rules no. Emma who cries the CSA. Instead say ube leading a witness no. Ube file the friend or witness statement. So witness statement no. Ako ye independently no one some. You know, yatro autocrat so. If you do something now, lawyer and son leading the view. Court no adopted. Court no adopted you are then other than any evidence in chief. So evidence in chief no black woman. And not so you big na a kutu no matter. The friend of cross examination no. Into amra. Yes, he had a witness statement about Betumuna lawyer Kotampa. Let's say our objections be raised. Now, objections now also be raised, and I'll say it's on grounds of 1, relevancy, 2, a bit scandalous and prejudicial, 3, a binum almost like any binomo improve pleadings na a court. It's okaya making the argument. So we are now the senior strategic attack. So ejina moabo. It take almost 2-3 hours. The court no yes on the court na no my the friend ruling no mokoya back. No, on paragraph this, where you trim, where you ever manage now, where you be and an account. It's almost very Anna, Ada. It's a tea, apple monso, on a mosquito, a BA. To the extent that portions of the witness statements are struck out. The rest, of course, no adopted as the evidence in chief. Then a court also adopted. I would say the rule of evidence, no say, sir, Oma testimony. Not objection will no independent take your objection continuously. That objection, the yet part of the course we processor, judge it me agent also. Any judgment.
na lawyer mami minye adwenkyere we interrogatories na beginning no mo de call ye no one of the arguments no say na mo pese oyi ano so that mo de be ka niam bi a mo pese court no etimi deliberate on any adanse bi ni bibia na mo sa ka se wa interrogatories no se wa anye antumu ayi add ni issue ho no a ebedru ba bia mo ye cross examination no it may or it might be overruled. But say
because you see, interrogatories really now court no matter. Court no can say on the basis of relevance. So now you say what's your evidence decree now and our evidence act sections 50, 51, 52. A cat will be expected. The overall consideration for any set of evidence to be admitted is relevance. So at the end of your relevance, admit unless at the end of your relevance that is repetitive, and I say more cumulative evidence, the system, be a bermuda. And I say the other can say a highly prejudicial. Who the grammar a bit poison the mind of the court. 8 years old. So Honorable can say, even though a relevant, because of the prejudicial value, now the basic law of evidence in the society, you don't count evidence. What's your judge here? Hello, Kwame.
Yeah, meet you.
You don't count evidence. Evidence is weighed.
It's weighed. We don't count it.
Yeah, you weigh evidence. You don't count it. And intina obi nyasama need the 10 witnesses at back court. Obi so the witness at the back court. Court the best no. Now court now say so the only one witness now back. The case because one who said the law is said that consistency is truth. That's what I say.
Me too.
Consistency no crap. Obi beba na sama work no no crap that story now woman no I am inconsistent. It's a court no be ignore no. No take the only any consistent baby I would no one would na.
From day one, say ya no.
From day one. Baby I would na no one would na.
Na a lawyer mami musadie with you. Na say day one ojina ho. Na oni adanse ana adanse no nye so substantial enough to support the claim.
Say civil.
I know it's okay.
Your proof proof on the preponderance of probability.
Sure.
And yes, like criminal matter, proof beyond reasonable doubt. So I say a civil matter. Did you hear say obedient baby a wojina? That's the meaning. So I can cast a crown here. Can you say asempa eyetia?
Asempa eyetia.
Okay. If they make any, on baby a or sometimes lawyer once here you get frustrated because one person can be more or say one meeting and one meeting. Over pressure over pen so on your own contradicting or say baby a meeting and one meeting. It's a nightmare of everybody doing cross examination. Who could share that kind of witness? He said, "Jina mosquito." Ube pushing is saying, "Baby, I would na no one would na." So I say because on your beer you can easily push over. It's one year you get to a point where in your mind no bedroom crisis or you're evasive. One person answer the question the way you want it, but that's his answer. You just have to move forward. The Friday no you do so ana electoral commission lawyer estati ebisa bisa jamosquito otutu ne numa sama na misconception be by obisa no some of the questions about the state of mind.
Mami hwe ade ba ko hansan ya to so adanse no a eba court n'animu no de yin na court no bogu ye na de yin na court no gitu mu na ye ntoa nsomfiri wo.
Oh, there were issues there were several paragraphs a bit of court no so and flow from the pleadings. There was some instance about 275 constituency coalition sheets. Court no say and have any expression from the pleadings. And so it is like pulling evidence from the back. One who said the rule of law on the church said, well, evidence are man, and have something in your pleadings. Into the evidence no come back, any grounding in the pleading. Now lawyer no out object here, it will form part of the record. The judge is bound to consider it. But the lawyer no take timeless objection there. The court must consider the objection and give a ruling on it.
Okay.
And some of the issues are raising, they felt that it will prejudice the outcome of the case. For instance, you must to make it very clear. So, their course, there was a predetermination by Jim Mensah to at all costs declare the election in favor of candidate Bado or cited familiar relation, among other things. And it's geared towards one outcome, to declare, in fact, or use the word to install. Now, you say, and you feel you're installation. Democracy, election. And you say, at the end of the
a word can be contextualized in that regard.
Fantastic. And Americano, in the context, it's possible. But the lawyers for the second respondent raised objections to some of those issues.
Okay.
There were about 7 or 10 of it. But in the course of the proceedings, something came up. There were questions lawyers for DC, Yamishinia, Justin Ametofo. Bisa question, the interesting thing is that Mr. Amenofo, the boss or Chambers, some are over the best man, Amenofo.
Okay.
That kind of relationship exists. But professional work is a lawyer for the Electoral Commission. Now, the Akobana said, Obisa question be a mosquito, Emma court who said, or no, yet the petitioner. Ubisa the state of mind. Ubisa no say. Did the petitioner not know, say, the result in say Techim and South has already been declared? He's not the petitioner. You don't expect him to answer that question. I am here testifying in support of the petitioner.
He was in the stead of the petitioner.
Okay.
He was in the stead of the petitioner.
No. Okay. He was not in the stead. He was testifying in support of the petitioner. One say, who can say you are in the stead, then you need a power of attorney.
Sure, okay.
But ultimately, paragraph 2 of the witness statement now, or making it very clear that I am testifying support of the petitioner. And it is different when the person is given a power of attorney. Once the person is given the power of attorney, then he comes to court as the petitioner.
Okay.
So let me give you a classic example. Osha 2013, Dr. Mahmoud Bami, I know a second petitioner, so okay.
Yes.
Good. Oba court no. Okay, and another one be testify. Jacob Bilante and be testify. And Bamia testify for himself and for the other 2 petitioners. When he is testifying for the other 2 petitioners now, he's not testifying as those 2 petitioners that be. That's it. So by saying I'm testifying for myself as the second petitioner, then what it means says, first and third petitioner had no testimony before the court. But when I say I am testifying for myself and for the other 2 petitioners, so at that point you become a witness for the other 2. And it is different. So when he testifies for the other two, he becomes a witness for the other two. It's not them. Just as in this case, Mosquito Ekaye said, he is not the petitioner. He is testifying for the petitioner in support of his case. In this Okobisane said, shouldn't the petitioner know, say, Petition and South has been declared? How do you expect him to answer that question?
Now, may ye move forward and then ya to say yes, ye bebo ye receiving Katia, it be. And no, Bibia, why not the Eba in support of the claim I will make it a Bibi in opposition.
Yo, Olga Tamakloe, filing a witness statement. Or filing a witness statement, no, or the envelope back home.
Eska. Yeah, maybe people.
A pen drive. They say the new 200 Ghana notes or the account. That a pen drive.
Okay.
Now, Mr. Kotampa starting a cross examination. Udum Pepe, so be a good besides the mosquito. Mr. Shedun Ketia. Wamanyoku or party officials can say Mahama in a winning among other things. No, Jam Mosquito, a year no say. It appears that we are one case I had the other court now. First of all, they say over Article 63. When you put in the word to me under the 1992 Constitution to make a declaration of election result. You see, me panel. The constitutional responsibility are all under Article 63. One for fulfilling that constitutional responsibility.
Okay.
So based on that, to an amount, unlike the 2013 election petition, Okaya, now Kufuado court say, pink sheet minimum of one, serial number now also, they say. Vote now, you are recorded on the face of those pink sheets. No. True. Or say, if the returning officers or more various polling centers, or man sign the pink sheets, contrary to their constitution, into no results now, award those pink sheets, that your body in a court will declare then candidate Akufo-Addo as the president. That's marked difference with the current petitioner at the court. Yenka will be say, but voter our pink sheet B, pink sheet 2, and now we now declare John Mahama as the president elect. That's different. The can say,
I want to point to be a material say. One was say a bus say, one can say electoral commissioner and fulfill her constitutional mandate now. So issue need is adjudicated the high courts rather than okay. Meaning so what is argument in the pen?
Yeah, Article 64 also be of the presidential election outcome called Supreme Court. In fact, Nanke Fale said he called High Court. Last minute from a raised preliminary legal objection, long for jurisdiction.
Matthias here, next
last minute, no more boom.
Okay.
In fact, there's a reported case, GS versus Yeboah. Sinyane, GS and Aja in 1960 election. So, we na 1 Yeboah. And then, of course, Supreme to challenge parliamentary election on a constitutional grounds. Supreme Court said that maybe I will know. And you hope a parliamentary election challenge. Article 99 said BBC no High Court. You were wrong for no book. That's a different kettle of fish altogether.
Now, and that tape I have a bono.
What is it?
And that tape no is in relation to what?
Good. And no, not yet. One with a court no can be because Mr. And no on the boat people.
Okay.
No more via one with a normal adjudication. We make testifier. Nina, they were the burden to produce evidence. But the law of evidence and so my I say make me up until with a piece of evidence. It's okay, and that Mr. Kujampa, sorry, not or making a point now. My Lord, and I'm a guy to be sound. So, Counsel, are you seeking to have this piece of evidence introduced to take the credibility of the witness? Say, yes, my Lord, that's what I'm trying to do. Say, then say so. I don't know, says, follow that part of the interaction. If you want to court, check it. The issues are stated. The 5 issues. I share that piece of evidence. Or share we are automatically the piece of evidence is irrelevant.
Okay.
But even though it is relevant, it's highly prejudicial. So on that basis, it will not be admitted. Which makes you also know the probative value is not outweighed by the prejudicial value. So on that basis, we will admit it. If you know, admit here, marking as exhibit 1 instead of A, B, C, D. Because usually, marking exhibit now. Plaintiff, no, the Sunday as an back also, or only exhibit here, marking with A. So, tender, opposite side, no tender that piece of evidence through the witness of your adversary now. You admit here, you have been marking as 1. Sana, your court in your man, okay. So in this case, no, I think a court, you both video in here. I think a court, no, key argument from the lawyers why that piece of evidence should be admitted and why it should not. If you mention, you the setup and the next step will be the legal argument whether that piece of evidence. It may well be, say, lawyers move here. Mr. T. Bechmiaka say, I did agree or dear bay, or whatever it is worth, it should be admitted. Because your case, say, Sebi. We are not in court saying that the court should declare say John Mahama as a winner. If that were to be our case, now all that piece of video at the bar, then you better show, maybe. For instance, Okaya.
It may not be admissible.
I want to know, Okaya in 2013, now after 2012, now the General Secretary of NPP, the senior brother, Tata,
Sir John,
Sir John. The deal will be a Nanko fan the crack.
Match, Mr. Do honestly,
may one price that they do not COVID restrictions on FINRA. Now, about Ponka crack. But not the American United States. Okay, in 2012, after the election, or your press statement be on the Boate Jackson. On the Babon, so MPP 4 and starting celebrating. Almost white shirt. Momon call.
Abakan wa house. Hiya.
Into your court no. Some your money in our because at that time no candidate was asking that the court declare him as the winner of the election. That's from the currency now. I'm sure, sir, maybe the only reason is just to demonstrate a certain political way. But in terms of the real law, and I make us say the 2013 petition, in terms of the release and the current release, they are slightly different.
Okay. And yeah, right, I mean, now, na wo ba de besi bia nso no yenim say ye no betsa atwetwe nkomo ho
that's right
Besme da sepa lawyer God Edudzie Tamakloe ne twe nkomo no wo ye aid ma former president Mahama na ewo petition no so no wo kasa e de fa ho be batwo
okayfm 101.7